On February 26, 2012, a 17-year-old boy wearing a hoodie and carrying nothing but a bag of Skittles walked through a gated community in Sanford, Florida. 44 minutes later, he was dead, shot by a neighborhood watch volunteer who had never been arrested, never fired a weapon in self-defense, and never imagined he would become the center of a legal firestorm that would reshape America's understanding of self-defense law. This is the story of when self-defense goes too far, and the 5 cases that prove the line between justified protection and unjustified killing is far blurrier than the law pretends. Let's talk about stand your ground laws. As of 2026, 36 states have some form of stand your ground legislation on the books. These laws sound simple. If you reasonably believe you face imminent death or great bodily harm, you have no duty to retreat. You can use deadly force to protect yourself, right there, wherever you are. No obligation to run, no obligation to de-escalate. You stand and fight. The logic is compelling. Why should an innocent person be forced to flee in their own home, their own car, their own neighborhood? The problem is that reasonably believe is not objective. It lives in the eye of the beholder. And when that eye belongs to someone with a gun, the stakes become lethal. In 2012, Florida's Stand Your Ground law had been in effect for 6 years. It was written broadly, and it was applied broadly. Self-defense claims had more than tripled since its passage. But no case would test the law's limits, like the one that began in that Sanford neighborhood on a rainy Sunday night. George Zimmerman was 30 years old, a neighborhood watch volunteer in the Twin Lakes community. That night, he was patrolling in his truck when he saw 17-year-old Trayvon Martin walking through the neighborhood. Martin was returning to his father's townhouse after buying snacks at a nearby 7-Eleven. Zimmerman called the non-emergency police line and reported a suspicious person. The dispatcher asked him to describe the individual. Zimmerman said, "This guy looks like he's up to no good or he's on drugs or something. It's raining and he's just walking around, looking about." The dispatcher asked if Zimmerman was following him. Zimmerman said yes. The dispatcher instructed him not to follow. Zimmerman said, "Okay." Then he got out of his truck. What happened next is contested. There was a confrontation. There was a physical struggle. Zimmer claimed Martin attacked him, pinned him down, and was smashing his head into concrete. Zimmer said he was in fear for his life. He reached for his 9mm handgun and fired once. Trayvon Martin collapsed. He was pronounced dead at the scene. No weapon was found on his body. No drugs were found in his system. He had Skittles and iced tea. Zimmerman immediately claimed self-defense. Police took him into custody for questioning but released him without charges. He had claimed he was standing his ground. The case exploded nationally. Trayvon Martin's parents demanded justice. The public demanded charges. 71 days later, the state filed a second-degree murder charge. But here's the critical moment. The judge allowed Zimmerman to invoke stand-your-ground protections. Under Florida law, Zimmerman could argue not just as a jury trial defense, but as a pretrial immunity hearing. If he could convince the judge that he reasonably believed he faced imminent death or great bodily harm, the case could be dismissed before ever reaching a jury. The immunity hearing became a trial within a trial. Zimmerman testified. Martin's girlfriend, who had been on the phone with him moments before the confrontation, testified about what she heard. Prosecutors argued Zimmerman profiled Martin, pursued him despite being told not to, and escalated a confrontation that never had to happen. The defense argued Zimmerman was on his back, being beaten, and used proportional force to escape. The judge denied the immunity motion. The case would proceed to trial. In July 2013, a jury acquitted Zimmerman of second-degree murder and manslaughter. They found reasonable doubt. Stand your ground was not explicitly used as a defense. Instead, the jury was instructed on traditional self-defense. But the law's fingerprints were all over the case. A man pursued someone he deemed suspicious, initiated a confrontation, and when a physical altercation occurred, used lethal force. The law allowed him to remain in place and defend himself with a gun. That case changed America's conversation about stand your ground, but it did not end it. In fact, it sparked 5 more cases that would deepen the moral and legal confusion about when self-defense becomes excessive. Let's look at Case 1, and this one happened in Tampa, Florida, also in 2012. Curtis Reeves was a 71-year-old retired police captain. He was sitting in a movie theater watching a film when a man named Chad Olson sat down in front of him. Olson was texting on his cell phone. Reeves leaned forward and told him to put the phone away. Olson refused. Reeves asked him again, more forcefully. Olson stood up and turned around. Words were exchanged. Reeves claimed Olson pushed him. Then Reeves reached into his jacket, pulled a 9mm handgun, and fired once. Olson was hit in the chest. He died before ambulances arrived. Reeves claimed self-defense. He said he believed Olson was reaching for a weapon. The cell phone Olson was holding became the critical piece of evidence. Did Reeves genuinely fear for his life because of a man with a cell phone in a movie theater? The prosecutor argued Reeves was a retired cop accustomed to authority, offended by Olson's disrespect, and escalated a minor dispute into a homicide. The defense said Reeves was intimidated by an aggressive younger man and had every right to defend himself. In 2014, Reeves was convicted of manslaughter. He was sentenced to 60 years in prison. But here's the crucial detail. The Stand Your Ground law was invoked as a possible defense before trial. Reeves's attorneys argued he had no duty to retreat from a movie theater. The judge rejected the immunity motion, meaning the case would go to a jury, but the law was still alive in the legal landscape. Fast forward to 2015, to Case 2, a gas station in Jacksonville, Florida. Michael Dunn, a 45-year-old man, pulled up next to a black Jeep at a gas station. Inside the Jeep were 4 teenagers. Loud music was playing. Jordan Davis, who was 19, was in the front passenger seat. Dunn asked them to turn the music down. The teenagers refused. Dunn claimed he saw a gun. He fired multiple times into the Jeep. Jordan Davis was hit and killed. None of the teenagers had a weapon. No gun was ever found. Dunn drove away, went home and slept. The next day he turned himself in, claiming self-defense. He said he believed one of the teenagers had a gun and was about to shoot him. The evidence told a different story. Ballistics showed Dunn fired 9 bullets into the vehicle. Security footage showed him approaching from the driver's side of the Jeep. Witnesses testified there was no gun. The prosecution argued Dunn was an angry man offended by loud music from black teenagers and that racial bias and road rage had triggered a deadly response. Dunn invoked Stand Your Ground. In 2014, a judge heard his immunity claim. The judge rejected it, finding that Dunn could not prove he reasonably believed he faced imminent death or great bodily harm. Without that reasonable belief, the Stand Your Ground law did not apply. Dunn went to trial. He was convicted of first-degree murder in 2014 and sentenced to life without parole. But notice the pattern. Even when Stand Your Ground is ultimately rejected, the law itself becomes a shield, a way to delay prosecution and file pre-trial motions that push the legal system toward the defendant's advantage. Now let's move to Case 3, which happened in Texas in 2007, before we move even further into the darker implications of these laws. In Houston, a homeowner named Joe Horn was in his home when he witnessed a burglary next door, at his neighbor's house. 2 men were breaking in. Horn called 911 and reported it. The dispatcher explicitly told him, "Protect yourself. Do not approach the burglars. Stay inside your home. Do not go outside." Horn ended the call, walked outside, and confronted the burglars in his neighbor's driveway. When they turned toward him, Horn shot and killed both men. He was never charged. Texas has a Stand Your Ground law embedded in its self-defense statute. It also has a castle doctrine law that extends those protections to your home and your occupied vehicle. But Horn was outside his home, on someone else's property, pursuing people he perceived as threats. The case was examined by a grand jury, and in 2007, no charges were filed. The consensus was that Horn's actions, though against police advice, fell within Texas's broad self-defense protections. The neighbors whose house he protected later thanked him. But the legal question remains unanswered in court. Does Stand Your Ground give you the right to defend someone else's property in the dead of night against your explicit police instruction? Fast forward to 2020 and Case 4, arguably the most disturbing application of Stand Your Ground law. In Louisville, Kentucky, a man named Breonna Taylor was asleep in her apartment at 12:30 a.m. when police arrived with a warrant. The warrant was for a former boyfriend who was suspected of drug trafficking. Police announced themselves as police, but Breonna's boyfriend, Kenneth Walker, said he did not hear them. Fearing a home invasion, Walker fired one shot. Police returned fire, ultimately firing more than 30 rounds into the apartment. Breonna Taylor was struck 6 times and killed. Walker was initially charged with attempted murder of a police officer. He invoked "Stand your ground." His argument was straightforward. He heard breaking and entering without proper announcement, reasonably believed an armed intruder was attacking his home, and fired in self-defense. In 2020, the charges against Walker were dismissed. Stand your ground had protected him from prosecution, even though he had fired at police executing a warrant. Police he genuinely did not know were police. The Taylor family received a $12 million civil settlement, one of the largest wrongful death settlements involving police in American history. But Walker walked away with a self-defense verdict protected by Stand Your Ground law. The case exposed a critical flaw. Stand Your Ground protections do not require that you know who you are defending against. If you reasonably believe you face imminent harm, you can use deadly force, even if the incoming threat is law enforcement. Which brings us to Case 5, and this happened in Arizona in 2009. A man named Michael Flores was in his home when 3 undercover police detectives, executing a search warrant for drug crimes, approached his door. The detectives were not in uniform. Flores did not know they were police. When they approached, Flores, who had a legal gun in his home, fired through his door, striking and killing Detective Jorge Lozano. Flores was prosecuted, and Stand Your Ground was invoked as a potential defense. The defense argued Flores reasonably believed armed intruders were attacking his home. The case did not go to trial. Flores accepted a plea deal, but it illustrates the same vulnerability. Under Stand Your Ground law, you do not need certainty. You need only a reasonable belief. And what is reasonable? That is decided by you in the moment, with a gun in your hand and adrenaline in your veins. So where does the line blur? Here's what we know from 2026 legal landscape. Stand Your Ground laws have been weaponized. Data from the RAND Corporation shows that Stand Your Ground laws increase homicides by approximately 8 to 11%, with particularly disparate impacts on young black men. Cases claiming self-defense under Stand Your Ground laws are more likely to be approved when the shooter is white and the victim is black. Prosecutors struggle because the burden of proof is inverted. Not guilty unless proven unreasonably defensive. Victims cannot defend themselves in court because they are dead. The Zimmerman case in 2012 sparked a national reckoning that was never fully resolved. Some states have tightened Stand Your Ground laws. Some have expanded them. The Supreme Court has not definitively ruled on Stand Your Ground's constitutionality, though lower courts have upheld the laws as consistent with the Second Amendment. The moral question beneath all of this is profound. When does the right to defend yourself become a license to kill? When does standing your ground become standing over a body you chose to confront? George Zimmerman pursued someone he deemed suspicious. Michael Dunn fired at teenagers who annoyed him. Curtis Reeves shot a man over a cell phone in a movie theater. In each case, these men invoked Stand Your Ground and asked the law, "Did I have the right?" In 2 cases, a jury said no. In 2 cases, the law provided a shield that never even got to a jury. And the common thread is not that these men were necessarily lying about their fear. It's that Stand Your Ground asks only one question. Did you believe you faced imminent harm? It does not ask, did you create the circumstances that led to that belief? Did you have a responsibility to leave? Did you have a duty to de-escalate? Did you bring a gun into a situation that could have been avoided? The law promises protection. What it often delivers is a way to avoid accountability for the choices we make before the moment we pull the trigger. In 2026, as states continue to grapple with Stand Your Ground, the question remains, how do we protect genuine self-defense while preventing these laws from becoming licenses for lethal overreach? The answer the courts have struggled to find. And every time a grand jury or a judge interprets these laws broadly, another person dies, another family grieves, and the line blurs a little bit more. What do you think? Should stand your ground laws be reformed? Should they be eliminated? Or do you believe the right to defend yourself should be absolute, without question or hesitation? Tell us in the comments below. And please, subscribe to The Verdict Room for the stories the legal system doesn't always tell you. The cases that define how justice actually works in America. We'll be back next week with a verdict that will shock you. See you then.